courtroom. We're ready to resume the trial. What is the status of the defendant's case?
Judge, we're not going to call any more witnesses, so we can go ahead and put on the record now, or I'll go ahead and put on the record now that we are going to, that Mr. Harris is going to waive his right to testify. We've been representing Ross since right after his arrest. So we've had an over 2-year relationship. During the course of our representation, we certainly have had the opportunity to discuss with him the fact that he has the right, constitutional right, to testify. So he's not aware of it just because we're in trial the last couple of weeks. He's aware of it because it's conversations that we've had over an extended period of time. I'm confident, I'm comfortable that he understands that he has that right. He also understands that the right is his to make the decision whether or not he's going to testify or not. We've explained to him the difference between the strategic decisions that the lawyers make throughout the course of the litigation and throughout the course of the trial, such as which witnesses to call, etc. He understands that this right is different, that it's personal to him, and only he can make that decision. I want to put on the record that we actually had a meeting with Ross this past weekend at the jail where we met to speak specifically about this subject and again advised him of what he already knew, that he has the right to either testify or not testify, that the right is personal to him, that we do not make that decision, that he does. We had a discussion concerning the fact that this is his one and only trial. There won't be a do-over for him to, make the decision differently at another point in time. I'm confident that he understands that. I know this has been a longer trial than what we usually have, and so the court, I'm sure, wants to be particularly clear on this matter for the record. I don't think I can make it any clearer. He's aware of his right. He wants to waive it. He does not want to testify in the trial of this case.
Of interest in the court, what estimate would you give altogether of how much time you all have spent in discussion of this particular topic? Just a guesstimate.
Over the course of the last 2+ years, many hours, I would say certainly we've discussed it. I wouldn't be surprised if it probably were 10 hours discussing just this issue.
Mr. Kilgore, thank you. I'm going to have a conversation with Mr. Harris at this time. Thank you, Mr. Harris. Mr. Harris, did you hear what Mr. Kilgore just said regarding the decision whether you would testify or not?
Yes, ma'am.
And you heard him say that he and the team of lawyers representing you spent perhaps in the neighborhood of 10 hours discussing the matter with you in the course of the 2+ years of the litigation of this case?
Yes, ma'am.
If you disagree with anything that they have said, you need to alert Mr. Kilgore to that or to me, and let me know if you have any disagreement with what's just been said to the court.
Yes, ma'am.
Do you have any disagreement?
I do not.
Now, as Mr. Kilgore has said, when we get to this part of the trial, a defendant has 2 rights. One is the right to remain silent, and the other is the right to testify. These rights are personal to you. They are not to be made by anyone else other than you. But they are a decision. This is a decision that needs to be made upon full and thorough conversation, discussion, and advice of counsel. Do you understand, first of all, that you have a right to remain silent and you have no obligation whatsoever to testify in this case?
Yes, ma'am.
Do you also understand that you have a right to testify and it is personal to you and that it is an absolute right that you have?
Yes, ma'am, I do.
Do you further understand that the decision to testify or not to testify is personal to you?
Yes.
And that no one else can make it but you?
Yes, ma'am.
Have you, in your opinion, had adequate time to discuss this topic and issue with your attorneys?
Yes, ma'am, I have.
Have you had adequate information from them and whatever other sources you may have?
Yes, ma'am.
Have you thoroughly vetted the decision with your attorneys?
Yes, ma'am, I have.
Have you thought about it yourself personally and internally had adequate time to consider your options and consider your decision?
Yes, ma'am, I have.
All right, it's been stated to me that you would like not to testify at this time.
That is correct, yes, ma'am.
And was that your opinion and what you wanted to do when it was stated to the court?
Yes, ma'am.
Is it still your opinion?
Yes, ma'am.
Do you need any further time or any further opportunity to consider this?
No, ma'am, I don't.
So you're satisfied with the decision that it's made and it's final and you're ready to move forward?
Yes, ma'am.
Thank you. Have a seat.
Thank you.
Well, I think that builds a record and I think we're ready to move forward. What will you be doing next?
We'll rest in front of the jury.
Bring the jury in.
Judge, before we do that, I'm sorry, if I may.
Sorry.
I've been alerted that the state intends to call a witness in rebuttal. I've been told that it's Detective Stockinger. So I guess I would make the request at this time as to exactly what it is that the state intends to rebut. They put up 51 witnesses.
Have you talked to them to ask them?
They have advised me that it's going to be Detective Stockinger and that they are going to play a recording. I assume it's a recording of Leanna Harris at the treehouse, but I don't know exactly.
Well, let me get back to my question. Have you talked to them? Okay. Have y'all finished your conversation before you bring it to me?
I thought we were finished with it, but I don't know that I asked that specific question.
Y'all should be talking to each other first.
This is like 2 recordings. And then this is, that's actually stocked in your feed. Those are the last 3 that are submitted. And then
You
these
said
are the
two.
recordings.
You talking about treehouse?
There's a little 5-minute recording that goes on for the transport as well. It's like a 20-something minute at the tree house, and then when they're taking her to the house, they leave the recording for an additional 5 minutes.
Okay.
Can you tell me what disc that is?
Do you have any
That
idea?
disc is, do you recall what disc number it is?
Do you need to know this, Mr. Pilgrim, before you ask?
Yes, I do.
Okay, I'll wait. I'm not asking that in a challenging way, just in an informational way. There's a difference.
Yes, ma'am.
It's slowly. I didn't take it that way, Judge.
It is 36.
106?
36.
36.
Yeah.
And this 36 would contain both conversations?
Yeah.
This is the only matters we're going to put.
Y'all are going to be going over with that. Yeah, you want to look at my outline real quick? Yeah, measurement, her interview. I'm going to end with her interview. That's it.
I'm ready to rest.
Well, let me reassert the reason I have y'all talk to one another. The rules of evidence, the rules of procedure, the rules of discovery are legion. They set out pretty much how these things are to be conducted, and you all 6 of you are experts in this area. I like to think I'm somewhat expert too, but the rules also favor that I resolve issues that you have a disagreement on. And it's my preference that when you all can communicate with one another and handle things, you bring things last to me, not first to me, because I don't need to interject myself in the nature of being an extra lawyer in the case. I need to be neutral. So that's why I keep first and more through this. And I know y'all know that, but I know that sometimes, like when you're trying to decide whether to rest in front of a jury, you kind of need some immediate information, and I understand that. But that's my default. It's the way I'm always going to go. It's just like judges are not supposed to get involved in negotiations on pleas, to leave that to the parties to do what you're supposed to do, to be advocates, litigators, and not get me in the mix of that part of what you do. So you did it well, and I appreciate it. Bring the jury in. Bring the jury in.
Let's all rise for the jury, please. Please watch your step. Please watch your step. Please be seated.
We'll reconvene the case. What says the defense?
On behalf of Ross, we rest our case.
Thank you, Mr. Coburn. Will the state have evidence at this time?
Judge, we have one rebuttal witness. I expect the direct of him, including the playing of recording, to last probably an hour, maybe a little bit less than that. We'll be ready to do that this afternoon.
And then there'll be some cross-examination as well. Ladies and gentlemen, when we started the trial, I gave you an overview. I said we would begin with opening statements, and then you would hear the evidence. Then we would have argument, and I would instruct you on the law, and you would deliberate. You heard the opening statements. The state presented its case. The state rested. The defense has presented its case. The defense has rested. At this time, there can be additional evidence in the nature of what's called rebuttals. The state has indicated that they have that evidence to offer this afternoon, and they've indicated a time frame. So it is sensible for us to have lunch and come back and have evidence again this afternoon. I told y'all yesterday I was hoping we would have a full day, and so we're making good use and good management of our time, and I think that's important. But there's no reason to get started, for 10 minutes and then take a break. That doesn't make good sense either. So let's take a lunch recess. Ms. Risa says that it's almost ready, and then we'll come back at 1 o'clock, and we'll move back into our meetings. Close your notepads, open mind, no conversations. Just enjoy each other's company and have the lunch. Thank you all.
Let's all rise, please. Please watch your step going down.
There you go.
Please be seated.
We can just wait till lunch. We'll have good lunch.
Thank you. Are you?
Thank you.